briefly announce our next speakers, my dear colleagues from the Department of Law, Faculty of Economics and Business, Professor Horak and Dr. Christian Poljanec. As you all know, they are also ones to blame for the organization of this conference. So please proceed.
Thank you, Zvonimir. I hope you can hear me and see me well. This research that we have prepared for this conference is in fact a part of our preliminary study that we conduct for the ELI Special Interest Group on Business and Financial Law, and one aspect of it is this presentation on solvency tests. Solvency tests as additional yardstick for prudent dividend distribution. Today there has already been some discussion about solvency tests by our Polish colleague, and we will focus now on the Croatian outlook. Solvency tests. Just a second. So our paper is divided in three major parts. So first part deals with legal capital rules as traditional rules for safeguarding creditors' rights. And we also tackled different theories that that pose criticism on legal capital rules. So the legal capital has faced severe criticism at the onset of the 21st century. Against this background, we have delved into alternative safeguards for protecting creditors' rights. First of all, some contractual means of creditor protection, property and company law tools, and one of those tools at the intersection of law and economics law and accounting, we can say, is the so-called solvency or payment test. And the third part of our paper deals with state of the art in Croatia and some regulatory prospects. So, as we have said, legal capital has received a lot of criticism at the beginning of the 21st century, mainly because it's being seen as inappropriate and impractical means of creditor protection, even detrimental to, especially for SMEs who want to incorporate under continental jurisdictions. That's why they fled to UK. Second of all, it's seen as a rather fictitious guarantee because creditors usually rely on the actual net asset structure and not on this nominal capital as stipulated in the balance sheet. And the third reason why this legal capital theory has received a lot of criticism is the fact that it's very mechanistic. So balance sheet solvency implies accounting and on the balance sheet parameters. However, this, let's say, more commercial position is trading solvency. So we should consider the company's actual commercial position and solvency prospects when considering whether to or not to distribute dividend. When it comes to, against this background, many have urged for revisiting legal capital rules. Company law experts in different reports at the EU level, also academia, especially Anglo-Saxon one, and even the CJEU in its three famous landmark cases, Centros, Übersering, and Inspire Art said, and I quote, legal capital is a necessary and potentially disproportionate means of creditor protection, and member states should seek to adopt less restrictive measures, for example, guarantees. So what does it demonstrate? What does it demonstrate is that we can speak about, it's a trend, especially in the Saxon countries, and nowadays even in some continental jurisdictions, is privatization of creditor protection, or we can say even, let's say, outsourcing it from the mandatory requirements of the Companies Corporations Act. And in our research, you can, of course, it's much more elaborated in the paper that will be published in the next issue, is the following. So we delved into the contractual and property mechanisms. I won't go into details now. So financial covenants, different third-party guarantees, letters of comfort, charges, etc. And on the other hand, on the other side of the spectrum, we have company law mechanisms, transparency disclosure, sound corporate governance practices, we have already heard about it today, business judgment rules, sustainable remuneration policies, and piercing the corporate veil. However, one of those, let's say, alternative safeguards for creditor protection is definitely the solvency test. It's mainly an ex-ante assessment of the potential outcomes of the decision to distribute dividends. So corporate board directors should issue a statement saying that, well, following the distribution, the company will not become insolvent. The company will not cease to be solvent, it will remain solvent as it was. But this perspective, it's very forward-looking, very sustainable, or we can say a going concern approach, given the fact that the directors should take into concern not just balance sheet elements, but also actual commercial position and economic circumstances of the distributing company. However, if it happens that the decision was based on maybe misleading or inaccurate facts, and in fact it happens that the company becomes insolvent, goes bankrupt, then the directors will be liable under civil law for unfounded dividend distribution. Geographically speaking, solvency test is a leading benchmark for dividend distribution under Anglo-Saxon corporate codes. So in the US, we have so-called twofold cumulative test. So in addition to this balance sheet solvency, we have trading solvency and solvency certificate. The same approach has been implemented by New Zealand, Canadian, and Australian legislation. However, what we have noticed in our research that even some continental countries within the European Union have decided to liberalize, to loosen the capital maintenance regime and introduce solvency tests instead or as a complement to the traditional minimum capital requirements test or balance sheet test. In the Netherlands, we've seen such an approach. The UK has already introduced it with regard to private companies when it comes to capital reduction, so distribution in this broader sense of the word. France did it with Société par Action Simplifiée, so with the public or joint stock companies. However, at the EU level, this criticism that took place 2 decades ago did not yield much results. So the SPE proposal, the proposal on Societas Privata Europea as European private company, failed due to dissenting opinions at EU level, in the EU Parliament. Also, no changes, we've noticed that no changes to the capital maintenance regime under the codification directive took place. However, what we can see is that rules on capital requirements are minimum harmonization standards, meaning that countries can introduce harsher rules, including solvency tests. And what we have noticed that this EU regime is, however, applicable only to traditional PLCs, those that are enumerated in the annex. So there is enough room for introducing simple forms of novel forms of PLCs like French did. Also, in recent time, EU cross-border conversion legislation introduced for the first time, if I'm not mistaken, this term solvency declaration and accompanied by manager's personal liability. So we can see there are some steps at the EU level forward to introduce solvency test, solvency assessment into perspective. However, as we saw with national regulatory changes, discussion on the future of the legal capital rules remains with the member states. And in this, after following this wider, broader context, comparative one, we are now trying to see, we're seeking to identify what's the Croatian approach, the Croatian outlook on solvency issues. So a Croatian system is based on EU capital maintenance regime, meaning in fact Germanistic tradition. However, there are no obstacles for introducing any private law arrangements for securing creditors' rights. However, what we have noticed is that under Croatian law, shareholders are entitled to receive dividend unless otherwise decided in accordance with limits prescribed either by law or statute, meaning that there is no room for some external financial covenants, US-type covenants, for example, tying the dividend distribution to company's net earnings. So there is no room for direct limitations. It would interfere with shareholders' competence. However, what is also possible under German law, according to KPMG study, is that shareholders can amend the statute, the memorandum of association, and introduce so-called collective statutory covenant, which could cover also external, which would cover direct financial restrictions. And I'm reaching my conclusion. Our conclusion, in fact, is that we have also noticed during our research, our study is that Croatian the Companies Act in Croatia also ties dividend distribution decision to so-called circumstantial tests. So in order to share dividend, what the shareholder meeting, especially the major shareholding, should take into concern is that not only preclusions by the law or the memorandum of association preclude the company to distribute dividend, but also circumstances surrounding the company. But on the other hand, we can see from the other point is that if there are, let's say, economic reasons for distributing dividends, so not to withhold it, and there are also no, in addition to that, legal or statutory constraints on dividend distribution, distribution should be divided. What does it in fact mean? If you take a closer look at the Croatian Companies Act, you can see that, in fact, when it comes to PLCs, there is a three-step procedure for prudent dividend distribution. It's a combination of legal, statutory, and circumstantial requirements. So there is a so-called implicit circumstantial test in the Croatian legal regime. It's also worth for LTDs. And it's my final slide. I hope I didn't cross the time. The time hasn't elapsed yet. Our regulatory prospects, in fact, given the fact that EU legal capital maintenance regime is only it's a block of minimum rules, so minimum harmonization standards, there is no reason why Croatia, as other countries already did, could not introduce solvency test as a complementary distribution restraint. This test could not override the balance sheet test because it's a minimum standard, mandatory standard under EU legislation, but it could complement it. However, American-style solvency certificates should not follow the solvency assessment. Why? Because Croatian system is shareholder-centered when it comes to distribution, not board-centered. So the final decision, say on dividend distribution, remains with not with the board, but with the shareholder meeting, unlike under US legislation. So solvency certificate would not have any legally justified meaning and, in fact, sense. When it comes to simple PLCs, why not? French did it, so why not? It's a non-harmonized area. It's beyond the annex to the directive, so we could introduce novel simple LTD within the Croatian system, which could also combine different models of solvency tests, so or complete abandonment of the mandatory share capital rules, which remain valid only for traditional PLCs, or we can introduce it as a standalone solvency test, or we could introduce it as a supplementary solvency test. More or less, it's the same with LTD, given that your private limited liability company law is still not harmonized, at least when it comes to capital requirements at EU level. So thank you for your attention, and we are looking forward to your questions in the Q&A section.
Thank you, Christian, for this interesting presentation.